you're there and that we know you're there and here and that you're listening even though your video. Oh, there you are. Leave it just like that. We see you. Perfect. Okay, let us begin. So, if everyone is now ready again, this is Wednesday, June 21st, 2023. And we thank you for being here. And we're going to keep our fingers crossed that technology hangs in there with us now for the duration of the meeting. We start with two work sessions, one on Clark County Public Defense Model and the second on the Transportation System Plan. After that, we of course move into council time. And after that, we have a couple of executive sessions. So it will be an intense morning. And with that, we turn it over to Amber Emery for discussion of, or kicking off the discussion of the Clark County Public Defense Model.
Thank you, Chair. Good morning, Council. Thank you for having us today for this very important work session. So I'm going to move forward. Kristen, if you can go to the next slide for me. So I'm going to save the introductions for when the teams come up to do the presentation, since we're going to be bouncing back and forth today. So I'm going to save that for that. You can see that we have a robust team of different partners in the law and justice sphere that's going to be joining me today talking about this important issue. Next slide, Kristen. So what we're going to be talking about today is kind of some of the history that's come before council before the current model. We have guests here from the Washington State Office of Public Defense. We have the Superior Court judges and the court administrator here to talk about impacts to the court of Superior Court. We have a couple members of the defense bar, and then I'm going to propose a new model that I hope that a council can consider, and then what those next steps will be. And then of course we'll all be available for question and answers with council. Next slide. So a little bit of the history, kind of going back to kind of where we are now. So in 2017, the General Services Department presented to council in a work session. The primary problem at the time was sufficient felony caseload coverage. That problem hasn't went away. So we've had that continuously since that time. They had recommendations that were not adopted at that time to add 2 internal staff attorneys and the indigent defense manager to also have a caseload. The recommendation was increased compensation. We have done that in some of our contracts in recent years, but it's still not on par with what contracts should be. So giving a little history of 2017. So 2018, we had a felony indigent defense work group that came forward to talk about, again, the continued deficit of contract attorneys in our community. Recommendations from the 2018 work group: increased compensation for contract attorneys, a public office defender office to assume 45% of the caseload, and that would include 16 FTEs, which 6 would be attorneys, or 18 FTEs, excuse me, and 6 would be attorneys. So just wanted to give you a little bit of the history that's come forward to council in recent years before we dive into what our current structure is today. So I received, thank you, Jeff, from the Office of Public Defense, some updated models that we had Friday. So as you can see with the coloring, the blue is Office of Public Defense in the state of Washington. So those are city or county state offices. Then you can see in the pink, those are contract managers. Those are experienced attorneys that are running those offices. So that's in the pink color. And then we fit in the white color. And what's telling in this area is when you look at the white, those counties are extremely small. So when you look at Clark County and the population data that we handed out in the handout, the fact that we are sitting in a contract public defense office, that one, we don't have an attorney running the office, which we haven't had for many, many years. This has been 3 or 4 years at this point in time. And 2, we're one of the 5th populated state or county in the state, and we do not have a public defense office. So I think there's two telling points of this picture. Next slide, Kristen. So again, the population data that we have that's in the pie chart, you can see in the state of Washington, the blue is Office Public Defense. So those are state, county and city, state or public defense offices. We sit in that yellow pie, and we are the largest appointed at. The closest point to us is Walla Walla, and they have 65,000 population. So you can see the discrepancy in the population difference. Next slide, Kristen. So now I'm going to invite up our partners with the Washington State Office of Public Defense, Jeff and Katrine. You want to come up to the counter here, and we're going to talk about some new legislative changes that have happened and also the challenges in Washington State, which we could probably spend an hour on just the challenges in Washington State, but we're going to keep a limit on that so we can get to the other pieces. Thank you.
Make sure. Hi, good morning, everyone. My name is Katrine Johnson. I'm an attorney at the Washington State Office of Public Defense. I am the supervisor for our trial level teams projects that we have. Let me tell you a little bit about our agency, our interest, why we're here. So first of all, the State Office of Public Defense, we actually manage direct representation in some certain areas of the law. For example, the representation of parents in dependency and termination cases. We manage that so counties don't have to. Appeals, cases that go up to the Court of Appeals or the Supreme Court. So there's some distinct areas where we provide that direct representation. We also, through our Public Defense Improvement Program, work proactively with county and city governments because we know the lion's share, the mass quantity of public defense is a local government function. We do provide some grant funds through RCW 10101 to Clark County as well as all counties statewide and many cities, including we provided funds to the city of Vancouver, for example, for many years, and Battleground as well. And through the grant program and working directly with counties and cities, we have the privilege and the unique perspective of learning about how public defense is functioning statewide in all the different places. We find that there's no one-size-fits-all, one approach, all that works for everybody, and there's usually many different local factors that go into what best serves the community and best utilizes local resources. So I just offer that in terms of that's the perspective that we can bring, going back to Amber's map there, talking about what happens for public defense in the different areas. And so if we can ever be a service to you in terms of sharing that information, sharing about their structures, who to contact in those local counties, we're sort of a centralized location to be able to help point you in that right direction. So we're here to help. Let's see, I think we were asked today to talk a little bit about legislative changes. What I want to talk about maybe more in terms of legislative changes is how that applies to public defense structures. Because there are changes in the law. I think probably one of the biggest ones we all know about is the Blake fix that happened at the special session. Now the drug cases are going to be filed in courts of limited jurisdiction, which have not faced them before. So now we have judges who are dealing with drug possession cases and attorneys who are dealing with them, toxicology reports and treatment issues, all of these issues that are going to be new within those municipal and district courts. And when changes in the law happen, the public defense structure has to pivot as well. And so I know one of the main discussion today is what model, right? What model to have. But what we see is in jurisdictions where there are attorneys who are either directors of agencies or attorneys who are managing contract services, they are in tune to what's happening. They can be involved with the legislative work groups from the Washington Defender Association. They can plan for how does this law impact public defense, particularly when it might not be obvious on its face. And there are many legislative changes happening. There's also changes happening in case law. Our Supreme Court, well, Blake, I think, is the obvious example of that, where there's changes in the law happening both at legislative and court level that makes us have to rethink public defense, what needs to happen with public defense, and what are the resources that are needed. And therefore, we really do recommend that jurisdictions have an attorney who can be on the cusp of that and report to you all to better explain to you all what is necessary at that point as well. With that, I'm going to hand things over to my colleague, Jeff Halsey, who's going to be talking about some of the biggest challenges we're seeing on a statewide basis right now.
Thank you, Council. My name is Jeff Halsey. I'm the managing attorney for the Public Defense Improvement Program. So in my position, I handle the application process and the disbursement of RCW 10101 Public Defense Improvement Program money to counties and cities. I put on our Criminal Defense Training Academy that we typically put on once a year, and I answer any questions that tend to come my way. And first off, before I continue on, I do want to say that Tori, who's sitting behind me somewhere, has been very proactive in trying to find answers to public defense questions. And I do want to give her credit for actually taking that opportunity to reach out and ask for assistance when she may not have that information. But that also goes to illustrate part of what we do, and that is to assist in understanding public defense policies, procedures, law. But I was asked to talk about the challenges in Washington State, and the primary issue that I believe Clark County is already seeing is recruitment and retention. That is across the board, not just within our state, but nationwide. There are several things that appear to be going on within the United States that is affecting public defense. First off, the American Bar Association has released several articles talking about the trends with employment of new grads and from law schools, and the paradigm seems to be shifting. When I was in law school, and probably before then, the general idea was the most desirable jobs were big law firms and government work. That seems to be shifting towards public law organizations such as the ACLU. So in these areas where we have seen graduates wanting to go to the government or big law, that's just not happening anymore. So while government, for whatever reason, has been less desirable, it's certainly affecting the ability to recruit and retain attorneys within not just public defense, but also prosecution offices as well. The biggest industry within law as a whole has been solo practitioners, who have seen a reduction by 30% year over year. And in Clark County, that uses a contract model currently. Solo practitioners are going to be a large pool for individuals to take those public defense contracts. And if those solo practices aren't there, then that pool dwindles. I recently gave a presentation to the Washington State Bar Association's Council for Public Defense on a survey that we did, and that was actually based on a presentation that Katrine gave to our State Board for Judicial Administration, in which we sent out a survey to public defenders, current and former, and we got about 500 responses back, and it illustrated a few things about public defense and the understanding of how public defenders view themselves. And the first is that public defenders don't get into public defense to become rich and powerful. It is very much a culture, much like the military, where people don't enter the military, don't enlist, don't become officers in order to become rich and powerful. They find a calling to serve, and they include their personality within that. So it becomes a big part of someone's personality, just like a veteran will see themselves as being a soldier up until they die. That being said, the main reason that people said that they would return to public defense is if pay were higher. However, the the conclusion that I can come to with that is that a lot of times the job itself becomes so untenable within someone's mind that it gets to you can't pay me enough to do this. Now, that sounds bad. I don't mean to make it sound bad. The issue behind that are the other responses to those questions, and it's respect. And it's respect from the other shareholders within the justice system, from the bench. And what Katrina and I have talked about specifically and in these presentations is that what it is that's lacking is the organizational support for these public defenders. The person who is in charge of a public defense agency, for example, has the ability to go to bat for that organization as a whole. It's not an individual public defender doing that. It's not a group of public defenders. You have structure. You also have support. Jason Schwartz, who's the current chair of the Council for Public Defense, had put it pretty well. It kind of struck me as being pretty close that as a public defender, we are frequently put in positions where we are defending people who many people would think are indefensible. And if we do something well in our job, number one, that's not expected. What's expected is that our clients are going to go to prison. But if we do something well in our job and we get an acquittal for our client, frequently we're not allowed to express that outside of our office. So if there is no office, there is no support for that, for those public defenders to have that. So having a public defense office allows that foundation to be there, that allows that support, that job satisfaction, and tends to be a more productive process and organization as a whole. So thank you. I believe I went over what was allotted, but I apologize.
Do you have any questions for us that we can answer now?
I think we'll bring you back up at the end. If we can keep going, is that good? Or do you have a question, Councilor Mevici?
Yeah, so one of the things you said that surprised me, that one size doesn't fit all. And in my mind, one size could fit all. It just needs to be scaled. You know, I'm looking for, in a public defender's office from this perspective, and I've had different lenses on this, someone that's responsive to our budgetary needs. Access, quality, you know, the fundamental tenets of what a public defender's office can provide. You're always going to have a private bar, however big or small, that the wealthier defendants can support. Then you'll always have, hopefully by contract, and it was one of my later questions on how you intend to approach this, a conflicts attorney list, you know, and then you have the public defense and quality, access to the general public. So I would think there are, and I have no familiarity with these nonprofits, and it's kind of a new concept for me here, and I'm wondering, how do they work? Do they work the same way? Do they meet my metrics as far as being responsive to budgetary needs, providing that access and quality across the board to those that need it in the public? So as far as, I mean, you must have some idea of, in Washington State, what works best. And that's what I'm looking to hear. I know Amber's got some recommendations, but, you know, we're going to do this once. We're finally going to get over the hump of, let's get this going. And I've been pushing on this since I've been a counselor, since before I was a counselor. And so, you know, I want to have the right model to go in with, and certainly with your view of the entire state, and, you know, who's got the most efficient system for delivering quality defense at reasonable cost to the county? I mean, do you have some recommendations as to how we do it?
Well, Counselor, I think that question in and of itself is going to take a great amount of time. Currently, we have 2 counties that go on the nonprofit model. That's Douglas County and Snohomish County. And both are succeeding at meeting the needs of their counties. The rest that have public defense agencies are governmental run agencies. I mean, I guess I'll pass it to Katrine about which one's best. I don't think that there's a straight up black and white answer to that, which I think that you already know just based on positing that question.
So I'd say when it comes to the nonprofits, the counties that have nonprofits, there's sort of a different genesis in each county on where they came from, but they certainly aren't creations of government. And so if that were here as a possibility, I think there could be that as an option. But if you currently don't have such a nonprofit, you can't wish it to be there. But just to explain from an administrative standpoint, so in those counties that have the nonprofits, they contract with the county, but they still retain a bit more independence because they're not actually a county agency. And so they have their own board the way any other nonprofit would. They provide usually the lion's share of non-conflict public defense to the agency, and it's a very reliable, huge part of the public defense contract. So that's how those function. But again, how you create it is going to be very unique as to whether there is that local interest even. I would say what works best, particularly for counties that are larger in size, is having a fully staffed public defense office. Within the office, you not only have, well, first of all, talking from what Jeff was talking about in terms of recruitment and retention, at some point you kind of run out of local attorneys who are willing to contract with the counties and come in and do the public defense work, especially now as we have baby boomers that are aging out of the business. And so the question is, how do you bring new people into your community? Are the graduates from law schools going to come in and hang up a shingle and open up a office on their own with no client base for a 1-year contract? No. Are they more likely to take a full-time job with benefits? Yeah. In a public defense agency, and I know this is not for all attorneys, but you have the management and the supervision in-house. You have training in-house. New attorneys can sit second chair on trials with the more seasoned attorneys. Or anything as simple as you're looking at your case wondering, what do I do with this? And you can just pop your head down the hall and say, hey, can anybody help me? Whereas if you're a solo attorney in an office, you don't have that same accessibility to support. And then there's resources. There's the support staff and paralegals, social workers, investigators, or experts. Having a team who are part of that, which should be involved in any model of public defense, but there's an accessibility of a team in that office. I think also with an agency within the government, they have a seat at the table within your county government structure. The prosecutor does, the court does, but the contract attorneys don't. They don't have a voice for them at the county executive level. And so if there are discussions about what's happening at the jail or resources or processes at the court, who is that voice for public defense? Who actually gets to talk to the county about the budget and what kind of budgetary changes need to be made based on changes in the law or changes in public defense standards? So it brings public defense kind of to the same level as the prosecutors are. It's not an elected office, but it would be its own side of that equation. There's always going to be contractors because there's always conflict cases. No agency can absorb every single case. So you always have to have a relationship with the local private bar. There are some counties where their agency absorbs a good 75% of all cases, and the 25% go out to contractors. And there's some on the other end of that spectrum where maybe their agency only takes 25% and 75% goes out to contractors. And that's an example also of not all agency models fit everywhere. It really depends on a lot of resources and interest at the local level. But making sure that there is oversight on public defense for quality, assuring that quality, I think is one of the most critical things you can have. Making sure that there is a voice for budgets so we get the resources for public defenders. And also just being able to be at the table to have these conversations. So usually that falls under that, again, the public defense agency model. That's what I personally would recommend. But if I can add one more piece, an important lesson I learned from the former Director of Public Defense in Yakima County. We were in Kittitas County. We were talking about what the future should be for public defense, and they recently had the same vote you're going to be dealing with, and they voted to go for an in-house agency. But they were talking, the group was talking about cost. Well, it's more expensive going to an agency than the contract model. And Dan Fessler said, he's like, this shouldn't be a decision about cost. The cost of public defense should be the same regardless of your model, because it's the same work. It's still attorneys. Attorneys need support staff. We need investigators. We need social workers. We need experts. We need management and oversight. When you look at all of the factors that go into well-run public defense, you still need all those factors. Maybe you do it on an employee model or a contract model, but the cost should be the same. And so if it's a discussion about this as costing too much, then the question really should be, how are we under-resourcing it under that other model?
So I just want to point out that just about every sentence you said was a really important singular issue that we could spend hours. And I know that Amber and her team probably has already picked your brains and gone through it. But I have one other question that it's kind of a nuanced issue, but you mentioned it in the partnership with law schools. You know, we don't have any close-in law schools here. And I'm just wondering, statewide, do we have a certified law student program where, and I see heads nodding in the audience. So, I mean, that's an important resource for both the prosecuting attorney as well as a public defender's office to have that interaction. And I appreciated the points, kind of quality of life. This is a calling issue, but we need to attract good lawyers to whatever model we set up. And I certainly do support a public defender model as well for all the reasons you stated. But so we do have a certified law clerk program in Washington State where basically my experience with it, you could get law students at any level in law school, and whether they're in a 3-year model or some other programs that seem to be evolving across the nation right now, they could come and have an internship, whether it was for credit or whatever. But to more formalize it, at least California had a 3rd year. When you were in your last year, you could be a certified law student under the supervision of a lawyer, whether prosecutor or defense, and they could appear on cases. You know, mostly misdemeanors, but as long as they were supervised by attorney, they could make appearances, which benefited the law school, benefited the student, but also benefited the office. So what exists here in Washington?
I'm so glad you asked that question. That's a really great question. What we do have here in Washington is we do have the rules and the structures to allow for that to happen. However, it happens at the county government level. It's not a state-run program. Our office is not authorized to run a statewide program for that. That's not part of our statutory obligations. It's a county government. And so what you'll find is in the counties where they have the structure, where they have a public defense office, they have these what's called Rule 9 or sometimes Rule 6 attorneys. So either students in law school or even students who are going through this in lieu of law school. But what you need to have is that supervision, that structure. Maybe in some unique instances, an attorney in a private firm might be able to do that, but that's a lot less likely, whereas if you do have an agency, you can build that in as part of your structure, which helps build that pipeline for future recruits as well.
Thank you both. Thank you. Can we go to the next slide, Kristen? And I'm going to invite the Superior Court bench, Judge Snyder and Judge Vanderwood, up to do this portion for Superior Court.
All right, thank you. I'm just going to make 3 very quick points, and then Judge Snyder is going to take over our presentation. My 3 quick points initially are, 1, as judges in Superior Court, we do have an interesting and unique position to see the impact of a public defense office and how those services are provided currently. Not only how it impacts our work every day, but the community. In a real world setting, every day we get to see those impacts, and that is something that gives us an idea of how important and significant this is. Second issue I'm going to mention is just that. As we've already heard, this is a very significant and important topic, and we appreciate that you as a council are in a position to be considering and taking on this important issue. It's one that's been long overdue from our perspective. Because it is significant, there are challenges that go along with it, but we are encouraged that you are in a position to really take on this issue and move it forward in a way that's going to impact our community significantly moving forward. And then the final conversation or point that I just mentioned is, even though we're advocating for a significant change in our system, we don't want to minimize the tremendous work that our contract attorneys have been doing for decades here in Clark County. They have been moving this issue forward in a way that has been, in many instances, heroic in challenging circumstances. So our advocating for a change isn't intended to minimize the work they've done. We want to honor and acknowledge that work, but we do need to move this issue forward. So with that, Judge Snyder, who's our assistant presiding judge and currently working in the criminal area, will focus on our remaining thoughts.
All right, well, good morning, everyone. Thank you for having us. And just want to start off with this slide here, which we're talking about last year. Actually, I think it was in November of 2021, we contracted with the National Center for State Courts, Superior Court did. We had opportunity, actually, Judge Vanderwood and I last September to present to council with regards to that, but we had 80% of you that weren't here. I think only Chair Bowerman was present for that, obviously with the new council. A lot of recommendations came out of that study. We as a court have implemented quite a few of them. We've implemented a new calendaring system. We've implemented a new governing structure. And along in the lines of this presentation, one of the recommendations that came out of that report was with regards to public defense office. They recommended a full-on public defender's office. And as Amber indicated, we are the most populous county in the state of Washington that does not have a public defender's office. National Center for State Courts obviously has a lot of history and research backing up the recommendations that they made for our court, as well as what they may recommend across the country for other courts. And one of those things, case flow management practices in criminal cases will be more effective with an adequately staffed public defense office rather than contracted private defense attorneys. Superior Court supports the adoption of a public defense model in Clark County. We believe that that will improve the quality of the indigent defense services. What the National Center for State Courts found is that having a public defense office means that there are staff attorneys devoted to the representation of indigent defendants and receiving effective training in managing those cases. Public defenders are charged with cooperatively working with the prosecutor's office to establish regular procedures for obtaining discovery and with court rules and for expectations from the bench. It would provide for supervisory attorneys who would take on serious and complex cases while supervising less experienced attorneys. Consistent discovery and investigative processes as opposed to the difference experienced with contractors. So all the contractors, they're doing, most of them have their own offices. They decide how they do everything. There's no consistency in terms of that. Public defense office would allow for that. We believe cases would resolve more quickly. This would mean a reduced jail population and detention costs. Next slide, please. We also believe that adopting a public defender model would improve the efficiency of criminal procedure in Superior Court. I don't know how familiar you are with our procedures in terms of criminal. We have 5 judges in the criminal division at this time. That's a change. We made that change in April of 2023 based off of the recommendations that we received from the National Center for State Courts. So you have 5 judges of our 11 judges who are doing nothing but criminal cases at this point. 2 of those judges every day are on dockets. So they can be seeing defendants on first appearances, arraignments, taking change of pleas, hearing motions in individual cases and that sort of thing. The criminal division, it's a very high volume operation. Our data indicates that we resolved around 2,200 cases last year alone. We are holding multiple, as I mentioned, those criminal dockets every day. That means that the criminal defense contractors are with us frequently in the courtroom. They can be pulled in one direction or another, needing to see multiple judges at the same time. And the reason we made our change, or one of the main reasons that we made our change, was so that we as a bench could have more oversight over our cases. One of the main points that the study had was that judicial oversight, in other words, more judicial touching of the cases, and it's a better way to go with the cases. It allows you to manage your cases more closely, better outcomes, quicker outcomes, and so we've done that as a group. One of the things we believe would happen with a public defender model, as I mentioned, where these contractors are kind of bouncing around from different dockets and seeing different judges, is to allow for a public defense office to have basically what we would call a docket deputy, which is very similar to what the prosecutor's office does, where there's multiple cases, could be, up to 40, 50 cases on a docket that one attorney, one staff attorney is handling for the prosecutor's office. The indigent defense would be able to do the same thing, where they'd be able to have a staff attorney come over and handle those dockets, as opposed to having, maybe 25, 30 different contract attorneys that have to show up for that particular docket to talk with that particular judge. So that would give the contractors more time to work on their cases outside of being in the courtroom, which would improve the efficiency and we believe the quality as well. Next slide. All right, so Superior Court General Rule 42, it's designed to safeguard the independence of public defense services from judicial interference or control. The Washington Supreme Court wants to prevent conflicts of interest that may arise if judges control the selection of public defense administrators or the attorneys who provide public defense services. They don't want judges involved in the management and oversight of the public defense services, including the assignment of attorneys to individual cases. So this is kind of a big deal because we do not want to be involved, nor are we involved in individually selecting attorneys to be on specific cases. So right now how this works is that the Indigent Defense Office recommends to us who we would be appointing on an individual case when that case comes in at first appearance, provided that the person qualifies for court-appointed counsel. Most of the people appearing in Clark County Superior Court qualify for court-appointed counsel. And if they don't, they usually show up at the first appearance with their attorney that they've hired. So when we're looking at that GR 42 and what we're supposed to be doing as judges, one of the things that the rule specifically states is that we are to encourage local governments to have attorneys with public defense experience manage and oversee the public defense services. And as has been mentioned by the former people that were talking, as well as by Amber, that is something that we have not had in this county for a while. And no disrespect to Tori, who has indicated has been doing a great job, is there are some nuances with having an attorney in that position in terms of the understanding of criminal law, specifically public defense, that an attorney brings to the table that has been missing. there's a lot that goes on in the office in terms of the management and oversight of the indigent defense attorneys, drafting, awarding, renewing, and terminating contracts, adding attorneys, removing attorneys from the list, setting caseload limits, et cetera. There's also quarterly certification that the attorneys have to go through to ensure that they're in compliance with the Supreme Court standards for indigent defense representation. That's a huge task with the amount of contractors that we have. All right, last slide, please. So as a bench, and since I'm the person sent over to speak with you, we want to make sure that the council understands that we are in support of the recommendations that you're going to be hearing from Ms. Emery in terms of making a change here in Clark County to a public defense model. We believe what she's proposing is the first step, and I know Councilor Medvigi said, you know, we only need to do this one time, but I think it would be a huge undertaking to go to just straight to a public defense model, full-on public defense model. As a bench, that is what we support long-term. Right now, we see this as a first step to getting to that place, and so we are in support of what Amber is going to be presenting here in a little bit. Any questions?
Madam Chair, I have a few questions for the court.
Go ahead, Councilor Medvigi.
Thank you. So most of my questions today, we're going to focus on how we manage our resources and get into those defense attorneys that need it. And it's just, I'll just kind of give an example of something we just approved yesterday, so it's fresh, and I'm wondering how it works in the courts right now. So we just approved some supplemental funding as a result of body cams and dash cams and the impact that on the sheriff's office, but also on the prosecuting attorney's office. And one of those funding packages is a software training package, transcription package, you know, so that the prosecuting attorney's office is going to have the capability of bringing in all these dash cam and body cam video and sorting through it, preparing for trial, and then preparing exhibits for trial. And, you know, the experience I had, we had a court rule that said if you're going to present something, you had to have a transcript. So all of that's going to be brand new and resident in the prosecuting attorney's office. How does the court deal with those issues right now? You know, for investigative work for the defense, for expert witnesses, and then when you have an issue like, hey, this one incident, we've got 20 body cam videos to sort through. How do you manage that fairly in court if the only entity that has the capability of handling and processing that evidence is the prosecuting attorney's office? I mean, I'm assuming you're dealing with these issues every day in different contexts, but this just came up as a new funding package, and also in my experience, salaries, you know, there's got to be parity. And you know, the experience I had before was we had a county counsel office, a general counsel office that represented the board of supervisors, in our case, county counsel. They got a lot more than the district attorney's office or the prosecuting attorney's office or the public defender's office. So we all joined together. We were almost going to, in fact, they ultimately did unionize just to get parity in public defense salaries. And I know that's not your issue, but it will be our issue. But as far as investigative work, support work, it was mentioned by the state presenters just a moment ago. I mean, that's of the utmost importance to have the public defender's office well supported in investigative capacity to prepare for trial. I mean, how are you dealing with those issues today?
You want to start and then I'll follow up?
Well, the body cam is just coming on in terms of it just got started, and so that's just starting to flow into our, you know, arena. And I would defer to Ms. Emmerich and Ms. Reardon in terms of what they're experiencing as contract providers. What we're experiencing right now with the court is continuances because that material is not available to be provided to the defense. And so I would let them, I think they're nodding behind me, but that's what I'm experiencing as a judge, is I'm being told, you know, I don't have the body cam from this supposed incident that's gonna, you know, either provide some supportive material for my client or maybe make this go in the direction of a change of plea. And so that's what we're seeing right now in terms of that. In terms of the investigative services, some of it comes before us for approval of the use of a particular expert or something like that, but the Indigent Defense Office is dealing with the cost of that. The judges don't get involved in that.
Councilor Meppici, if I can add to Judge Snyder's point, and Ms. Emmerich and Ms. Reardon can speak to this in its entirety, to the point that, you know, that was made that we don't have a seat at the table for those conversations that come online. So when the technology was chosen for the prosecuting attorney's office to view the evidence, it was not trickled down in the right way to get to the defense contractors, meaning when the evidence link is sent out, it's a download-only link. And if you're talking about 12 body cameras that you're downloading to a computer, that's a full day of downloads, that you may need this a little bit for, you know, an exhibit for trial. So we are dealing with that, and Christy and I and Tori and the defense team have been working on that for the last month since the city of Vancouver came on, because that's what we're seeing trickle in now. There's those technological packages that need to be addressed, and I've talked about this with Kathleen, and we've talked about that with Emily, as far as the Indigent Defense Office is to be able to be that hub for now, to be able to get those pieces to the attorney, but it's an issue.
Can I just clarify that? Because I'm surprised to hear that the court aren't directly involved in that. So if you've got a felony case that needs a lot of expert defense work, that goes only to our office. The court doesn't weigh in on approving funds for additional capacity. Interesting. Okay.
Yeah, we hire
And do you approve them all the
I
time?
do.
Okay.
I do, yes. So that is something that Tori coordinates, and we make sure, because that's within the rules, that the evidence, or that investigation is up to par. So we need to, we approve those very quickly. And there's some that come over our threshold, that sometimes the judges will order a special, you know, expert, or an attorney will request a special expert, and as long as it meets all the criteria, we'll approve it, because we don't want to hold up a case. So yes, those are coming through on a daily basis.
So at some level, you do get involved in an ex parte communication with the
Pretty rare. I was going to say, it's pretty rare, yeah.
No.
to approve special funds.
Not on an ex parte basis, but sometimes motions will be presented that we'll consider and review.
Yeah.
Yeah. This issue about access and timing is one that you single out the body cam issue, but you're right. I mean, it's an issue in lots of different cases in lots of different ways. And it's one of the reasons why, as a bench, we're supportive of moving to this model, because as it is, it's a little bit on an ad hoc, case by case. It puts contractors in a challenging position to try to properly represent their clients, given the volume and work that they need to be doing.
And I think we'll touch on this when we get to the defense section, as Judge Vanderwood pointed out too, is when there's not a singular voice at the table speaking for the defense, like there's not a public defense voice sitting there saying, this is going to impact our office in this way, we can't get evidence links out to the attorneys, or whatever it may be, that's lost. And that's lost time, that's stuff that we have to play catch up on, and that's what we're doing right now with the body camera. So it is a hurdle that Ms. Reardon and Ms. Emmerich, I'm sure, will speak to when they're in their sections, yes.
Thank you.
Thank you.
Thank you, judges. Okay, I'm going to invite Ms. Emmerich and Ms. Reardon up here to talk about it from the defense bar perspective, and then we'll wrap up with the proposal.
Okay, apparently I'm going to start first. My name is Carrie Reardon, and I am the president of CDAC, which is the Criminal Defense Attorneys of Clark County. I probably have a more unusual history because I am now in my entering 27th year of practice, and all 27 years of my practice and 1 year as a Rule 9 intern for the City of Spokane Public Defender have been spent in public defense. This is the first time I have not been part of an incorporated office of indigent defense, and I'm assuming you could tell by the graphs and charts, it stresses me out regularly. Amber gets to hear regularly, when are we doing this? What are we doing? So I probably can answer a lot of questions that you may have. I'm just going to start at the very basics. We are governed by the rules of professional conduct, most importantly for indigent defense, by the standards of indigent defense, and then also by the Washington State Bar Association standards of indigent defense, which are slightly different from each other. Those standards of indigent defense are based on a fully supported attorney, and there are very few offices. Ms. Emmerich has a fully supported office. I'm a solo practitioner who has to pay out of my pocket for legal assistance, which isn't covered by my contract. And so on a daily basis, you have people who, in no way do we have parity with the prosecutor's office, but we also don't have parity with the prosecutor's office in the fact that we don't have support staff. To get any service, we have to fill out paperwork, wait for the paperwork to come back, go through a bunch of steps, so it all takes time. And while I did appreciate the bench saying a public defense office will make for speedier case resolution, the reality is our jobs as attorneys are to our clients and to do our best job. The results of the current system is that everything is delayed and there are a lot of continuances. I don't know that a public defense office is going to mean that things speed up that much, because it does take time to adequately investigate cases and to do the jobs that we should be doing. What I think the result will be is that you will find that those that are in jail or being charged with crimes are provided better indigent defense. So I know that there are little slides for me. I can't read upwards, so I'm just going to keep talking from my notes. Part of what RCW 10-101, which Katrine mentioned, talks about is that the legislature has found that representation must be provided for indigent persons and people who are not able to contribute. In this county, we don't really do an adequate screening to see who is indigent and not. People just tell the judge, no, I can't afford an attorney. I suspect that we are one of the only counties that does not have somebody doing actual screenings for indigency. And it is shocking because there may be people who could contribute towards the cost of an attorney, but that doesn't occur. But what we also say is that we are to do this consistent with constitutional requirements of fairness, equal protection, and due process in all cases where the right to counsel attaches. And where we don't right now have everything that we need is that, A, we're not having parity. So we have to pay out of our pockets or we go through these other things. 10-101-030 requires that standards be set, and there are actually standards of indigent defense that have been adopted by the county back in 2003. They actually require parity. We don't have that. So the standards the county council adopted, I believe it was county commissioners at that time though, required parity, and it's not followed. The prosecutor's office all got a pay raise. None of the public defense contractors did. So those are those sorts of issues. It also requires things like training, supervision, monitoring, and evaluation of attorneys. What doesn't occur right now with indigent defense is training, supervision, monitoring, and evaluation of attorneys. Judge Snyder talked briefly about the fact about renewing contracts and those sorts of issues. In an ideal world, you have somebody managing your indigent defense who is able to do evaluations and supervision and to address things when people are not following court rules, the RPCs. Maybe they have deficits, but we don't have any of that. You can maybe kind of, nudge somebody and say this may not be the best way to do something. But except for in the rare office that has more than one attorney, you don't have that. The vast majority of contractors, and I have to imagine Christy may know more, I think probably 80–90% of contractors are sole practitioners. And that's a deficit to the county. It's a deficit to the bench. It's a deficit to the other attorneys because we don't have that camaraderie. We don't have that ability. One of the things, I made a very long list of benefits of an organized office. Number one was training, and I think that is very, very key because there is not a great deal of training. There are a bunch of laws going to an effect, effective July 23rd. Who's training people to know what those new laws are, what the legislative updates are, what's going on? There are changes to the competency evaluation procedures. Without that training, people don't know and they learn after the fact. There's more direction. As has been mentioned, there's a seat at the table up front and to do these sorts of things. I worked for years in Spokane County, and that was one of the first places as a result of a lawsuit to have body camera. We typed into our happy computers and up popped body camera that you could watch. The disaster that is body camera right now, it is a deficit to each attorney trying to figure it out, to each support staff that is there trying to do anything, and to the defendants who don't have a really good way of knowing what happened. And so the defense bar at this time is simply just at a deficit. It also indicates that, and one of my things was, I said, in an office with a healthy work environment, people stay. There is greater systematic knowledge, there is stabilization. We don't have that. People keep leaving, and I'm one of the few that I think has come, but people keep leaving. One of the attorneys very involved in CDAC to this day regularly talks about to us about her great job in Thurston County, where she's making way more money than any of us, and has that support, but we don't. There's cooperation, and that happens anytime you just have organized defense. Grace Harbor County has an attorney that is leading it. Grace Harbor County is able to do systematic training for their attorneys. So you have deficits that way. There's increased commitment. And one of the things that has always been true of public defense offices is that your low bar is raised. Absolutely nobody wants to be the worst attorney in an office. And I don't know a better way of saying it, but that really becomes the truth, is nobody wants to be that person. And you can very easily address that low bar. Like, you're not doing what needs to be done. This is how you do it. And I think the main issue here is for indigent defense in Clark County is incorporating, most importantly, having an attorney running indigent defense and having an office, is that morale will increase. And when you increase morale, you wind up with better results and more commitment. At this point, indigent defense, I feel like we're often Oliver Twist, and we're, putting our hands out, please, sir, may I have some more? And we don't, that's where we are. And we wouldn't be in that space any longer. We'd be recognized as a very important part of this county's investment in providing a vigorous criminal legal system. We do it with the prosecution. The judiciary is able to address things, but the defense attorneys all kind of lack direction in a way that I think would be a huge benefit from an organized defense agency.
Good morning, Christy Emmerich. I am from Vancouver Defenders. I'm the owner of our firm holds county contracts for your municipal court. So we handle all misdemeanor cases in district court for both the county and the city of Vancouver. We also do a large portion of felony work as well as juvenile. I'm here to kind of give you a little background on why district court is working perhaps a little bit more efficiently than your superior court is. We're one of the organizations that is probably in all courtrooms, and so I can see throughout our judicial system what's happening. We are, if you wish, a de facto public defender's office here in the county because we have what you were talking about, the training, the stability, and the seat at the table. For us, because we do handle everything in district court, when we have issues that arise in district court, we are there. I'm at the table alongside the city of Vancouver, the prosecutor's office, and the judges, and we're making decisions and policies that affect our court system. In recent years, we spent 3 years developing and finally implementing our community court. Regarding, Blake fixes, currently we are meeting every week talking about how that is going to affect us in district court. These new drug possession cases, what is that going to look like for our resources? What is that going to look like for our time? Do we need to develop new therapeutic courts or ways of handling these cases? We're having those ongoing conversations. When I see an issue, recently, as a result of COVID, of course, we're doing Zoom hearings more and more. Because of that, we are having a difficult time speaking to clients who need interpreter services. You can't have that same interaction with a client over Zoom who needs an interpreter. I brought that issue to the bench, and we created what we're calling our interpreter docket. We have them every other Wednesday, and it's a docket devoted entirely to folks who need an interpreter. And we have all the interpreters together at one time. It's a huge resource save. Instead of them being in multiple places throughout the week, we are condensing those resources. The attorneys are present, and we're able to meet ahead of time before the court docket starts, so we can have conversations and meetings with clients. And then we go into the courtroom when we're ready. And it's been a huge problem solver. But those are the kind of issues that arise and that we are able to fix because we do have someone at the table, working with the other judicial partners. So I think that is a huge part in why we're working well in district court that we don't have in superior court. We see issues, we talk about issues, but we don't have anyone to move those forward. Counselor Medgivi, the issue with the body cam. It's an issue, Mr. Golick's office was able to bring that to the court, to the council, and you can address it. It's an issue on our end, but we don't have anyone, we should have been there from the beginning saying this is going to be a problem. If you're going to create a system where we have to look at body cam footage, defense has to look at body cam footage. And what I'm fearful, and I know is going to happen because this is new, in about 3 months, it's going to cause a huge slowdown in superior court. We're going to be asking for continuances because there are cases where we cannot access discovery. We know the discovery is there, but we don't have a means of seeing it or accessing it. And that's going to absolutely come to a grinding halt in superior court this fall when all those cases start hitting. When we talk about budget needs, I review our billing for our office. I review it. What's appropriate, what's not, what we're, and I make those decisions before I submit them to the county. Training, Rule 9s. I started at Vancouver Defenders as a Rule 9. I was a law student my last year. I came over, I trained, I learned, I became an attorney. I worked in misdemeanors. I worked in superior court, and now I'm running the office. That's 17 years of work here dedicated to my firm because, that's the culture of, of Van Deff, and that's what we call ourselves. We have created a structure of support for attorneys. Every year we hire Rule 9s. We work them through their, last year in law school. We're training them. We bring them into district court. And as long as they don't lose them to the prosecutor's office because they can pay them higher, they're with us. We have half my attorneys have over 10 years experience, upwards of 20. So that is a level of consistency, a level of knowledge that we're bringing to the table and support for our attorneys. Like a solo practitioner in Superior Court, you are alone. You need to come home to your office and bounce ideas off. You need to say, hey, have you ever seen a case like this? Is there a case that does this? And you need someone to talk to and learn from and bounce ideas off of. And when you're alone, you don't have that. We pool our resources. You want to take a vacation, you go on maternity leave, you have to have someone filling in. The contractors don't have that system. It's very ad hoc. Every morning there's an email that goes out, hey, I need help, I need coverage, I'm sick. Or, an email will go out and someone's like, hey, I'm in trial today, I have no one to cover this other case. So there's a constant pulling of these contractors. And that's not quality representation. If you can't arrange for coverage until the morning of, that's not quality representation for that client. So those things are happening routinely in Superior Court because we have those, individual contractor models. The other thing I would point out is something that the OPD brought to your attention is the dwindling attorneys that are coming into town. The bar passage rate for February of this year was 30%. That's unprecedented. Typically, a bar passage rate is around 70 in our state. We were 30%. Oregon, who I like to steal their attorneys to, was at 40%. So this young crop of newly graduated law students are not qualified yet to be appearing in courtrooms. We have an aging population. Our contractors are retiring as fast as they can. Every year we are losing good contractors who've served this county for their entire careers. They're retiring now. We don't have any young people coming in. And on a personal note, I will tell you, these young attorneys are different. They don't want to hang a shingle. They don't want to fight alone. That's not who they are. The attorneys from 30 years ago, that's what they knew, and that's what they were willing to do. This new crop of attorneys, they don't want to do that. They want to come in with benefits, and they want to know when their retirement is, and they want to work. But they don't want to have that fight. They don't want to have that responsibility. So we're seeing less and less contractors. I don't believe we have enough contractors at this point to service the number of cases we're going to have for this year. Who's going to handle those cases? And so that's, and that's only increasing every single year in Superior Court.
Any questions for the defense side? Carrie and Christy? Otherwise, we'll move on to the next section. Good? Chair, good with that? Thank you both. Next slide, Kristen. We've touched on many of these through our conversation, but I want to bring attention to the right side here. We have currently 30 murders sitting in our jail, attempted murders and murder cases. Those are really complex, as we've heard through many of our cases are complex, but those bring a level of time. They're a long case that takes a while, a lot of investigation, a lot of evidence review. I just want to point out a couple stats. In 2022, we paid 2 homicide cases. We're billed over $55,000 and $87,000 for just one case. So those costs tend to rise. And I know that OPD, we're talking about looking at it from not a cost perspective, and I don't want to do that, but I want to also call out that those costs keep rising. The amount of attorneys in our community keep falling, and that quality of the attorney that can do those serious cases are leaving in droves. So we're going to be at this point in time where our need is not going to be able to be met, and we're, as Christy pointed out, at that point right now, we're at a tipping point, very much so in our county. Next slide, Kristen. Okay, so as we kind of have talked about this from fall of last year, is how do we get this proposal, how do we get this office started? And so the proposal in front of council is what we're looking at is a Director of Public Defense Services. It's a reclass of a management position that we currently have. That is a managing attorney. That attorney can have caseload. When I did a lot of the research at the end of last year, I talked to Benton County and a couple of the other counties up north about does their director, does their managing attorney have a caseload? And so they sometimes have a small, but it's flexible to be able to do what the office needs. So that's what we'll be looking at reclass. The next position is a senior public defender. That's close to the chief, and we'll talk about the parity on the next slide. Public Defender 2s, I'm not married to the name. There's lots of naming conventions out there. That's a high-level public defender that can do A and B felonies, which is the deficit that we're facing in our county. The legal services managers, that's basically managing the office side of what the investigators will be on, the legal assistants, and the office assistants. So next slide, Kristen, please. Okay, and we talked about this in numerous presenters have talked about this today. So Oregon, and I think many of you probably have read the papers and saw the collapse of the Oregon system last year with their public defense. I spent almost 7 years of my career over in the courts in Oregon, and it's very much like the nonprofits, the consortium model. So the state pays for it, it's funneled down to firms that are in the community, and what they saw from the get-go during COVID is they currently do not have enough public defenders to handle arraignments. So they're dismissing cases in droves currently right now in the state of Oregon. So what the biggest piece that we still hear, even though they've done a lot of work with the restart of their public defense office, they still didn't do pay parity with the PA's offices in Oregon. And so my recommendation, and the team supports, is we will come out of the gate with pay parity with the prosecuting attorney's office. And so what that looks like with the positions that I listed, so the Director of Public Defense Services would be on parity with the Chief Deputy Prosecuting Attorney, which is the one underneath Tony, so the one underneath the elected official. The Senior Public Defender is the same parity with the Chief Civil Criminal Prosecuting Attorney. So you're managing the office, you're supervising, so that level of experience is needed. The Public Defender 2s will be the Senior Deputy Prosecuting Attorneys, so those are your most senior folks that are in the office, and that's what we'll need to be recruiting from the very beginning. And then, of course, the office manager, and then, of course, the legal assistant, which will be some of the support staff that's needed for that office. Next slide, Kristen. Let's see if we can blow this up. This is just a visual of what this will look like. And what I'm really important to put is this is the foundation. I know Judge Vanderwood and Judge Snyder mentioned that in their presentation. This is just to get us off the ground. This is a very, very complex and very long intensive. We have cases that last 2 to 3 years in our county. So if we came in tomorrow and said, we're starting a full public defense office, we're letting go all of our contracts in 2024, we would not be able to do that. So this is a rolling piece of us being able to get the foundation started with the deficit that we have in our county, which is the senior cases, the A and B felonies that we are needing to address. So this is the proposed foundation of what that will look like. Next slide, Kristen. Okay, so to the budget and fund. So as we've been talking about public safety sales tax impacts to what that would be and what we could potentially use that for. So I've listed here, and this is just a proposal, of course, of what that would look like. So to start the FTEs, which would be the 7 attorneys, 3 legal assistants, proposing to pay that out of the public safety fund. And so will you scroll down a little bit for me, Kristen? Let's see. Maybe it's me. Okay, it's me. And then that would leave our contract fund in the general fund alone for now. So as we do our transition away from contracts for those particular points and cases that are given, we'll start that foundation in our office. And that foundation, the cases can start to be assigned. We have supervising attorneys that are in there, and we can start to move those cases along. So the new cases assigned would be to those folks as well as our contracts. As those come online, and as we start to add to the office in 2024, then we can start to transition the contract out. And when I talked to the budget office about what would be the best proposal of what this would look like. It's clean to see the FTEs in one side and then the contracts in the other. So we can set metrics up to see how when the contracts go, that amount of money would go back to the general fund, and then we could see how that would look in both sides of the coin. And we have that in our public defense, or in our indigent defense office now. We have 1033 funding that's used for our therapeutic courts, so we can definitely see what that funding is used for and the metrics that go along with that. Next slide, Kristen. So I just want to be clear. I think that when I called out the historical presentations of what that looked like, there was very clear-cut definition of, we can let this contract go, it's going to save this amount of money. I want to be clear, our cases, to get to disposition on our cases, they take a while, and we talked about that in many ways in our presentations today. So 2024, 2025 would be our transition year. So the goal that I would have if this proposal is adopted by council and get the direction today would be that we would be looking at hiring the director, getting that on board, and asking for the FTEs, which would come in front of council. And then that would get us our foundation of the office, and then we would add on those services as 24 and 2025, and then the contracts would start to dwindle out. We will always have contracts for conflicts. We've talked about that today in numerous ways. We also, as Christy talked, misdemeanors work in our county. We have a unique area in our county that misdemeanors are covered. They have one voice, there's one office, and it does well. And I know, coming from personal experience of being at district court, Christy had a seat at the table and we were able to problem solve. So that office works well. And we have juvenile and we have therapeutics. So this allows us to focus on the felony side, which quite frankly is broken. And we've talked a lot about the ecosystem with the jail and the conversations we've had around the jail. That is a part of our ecosystem here that is broken. And as we come online with the jail and start making fixes there, this is the other piece of the coin here that is very, very, very important to start addressing. And then Christy touched on this too. Sorry, Kristen, one more thought in my head. Christy touched on this too, the recruiting and the hiring. And we know that we've been going through a compensation study with Baker Tilly that we'll be bringing in front of council in July, and what that's going to look like for our county. So for us, it's really the recruiting and pulling those folks in from different areas. We have to be attractive. That's what's going to bring attorneys to our county. And as Christy mentioned, it is a different crop that's coming in. They want to be part of a structure. They want to be part of being able to do their job and go home. As many of you know, sole practitioners sometimes work 80 hours a week, right? 70, 80 hours a week to do certain things. So that's not what we're seeing with the current. So we have to be attractive right out of the gate with the recruiting and the hiring. Now, next slide, Kristen. Okay, so this is just a recap of the timeline. So we did our outreach. I did my outreach last year with a couple partners to the courts, the prosecuting attorney's office, the OPD, and then members of the defense bar to start this conversation of what we could do in our county. And then, of course, the work session is today. Based on direction or feedback given to me today from council, I'll bring forward the classification and pay scale, because that's in your purview to approve for the public defenders, and if this is the way that you want to go for the particular office. And then, of course, working with the budget office, we would need to set those up, and then the hiring and onboarding would hopefully start in fall 2023. And then, of course, we talked about the phasing. Next slide, Kristen. Thank you for hanging with us today in all of our presentation. We appreciate it. What questions can we answer for you? Madam Chair.
Amber, thank you, and everyone who presented this morning. It's been fabulous. I know I personally, and I think some of the other counselors, have long been supporters of having a public defense model. And I have to tell you that there was two words that just popped out at me. Part of my prior life was teaching systems theory and putting together a system that made everything work together and feed together so that it was successful as a whole. And one of you said, and what we have right now is an ad hoc model. Oh my goodness, my head just explodes when I hear that, because we really cannot be successful with that type of a model, and moving away from that is critical. Now, how to do it? And that's a big question. I think that council can authorize some general forward movement at this point, but I don't think we're in a position to be able to offer specific forward movement on all of the specific points, because A, there's too many of them. There's a lack of in-depth understanding that we need to have on behalf of our public and others before we're able to do that. So those are my general thoughts. I would welcome the thoughts of council as we ask questions and figure out where to go from here.
Great. Thank you, Chair.
I'm happy to start off. So this is an executive function, and I so sincerely appreciate where we are today. I wish we were here years ago. Just do it. You know, Franklin Delano Roosevelt said, just do something. This is a good start, and the transition is going to be the most important aspect and probably the most complex as we cycle down all these 80-plus contracts down to a singular conflict, attorney conflict. So the transition will be important. You know, I appreciated the reference to Oliver Twist, and you know, we have to have parity. And for the public, I just want to say this because I've had, you know, I was a prosecutor for 25 years. And I was a pretty hardcore prosecutor, and then I was later a judge. And I certainly transitioned through a lot of phases on how I viewed defense attorneys and public defenders in general. And I think, you know, that for the general public, they still have a different view. And I just want to say, it's a cornerstone of our justice system. Nothing works without good, competent defense attorneys. Nothing works. And we're so inefficiently operating right now. And I mean, you're not even getting to the quality issue and access issue, but it's so inefficient with our money. And taxpayers should want to know that. We want to spend our money wisely. And for those taxpayers out there, you have to really think to yourself, what if it was me? What if it was my child? Someone near and dear to me. You want the best defense for them. You want competent defense. You want a baseline defense. So we need to do this. We need to move forward. We'll work out those details. The executive will. And just focusing on the transition, it looks like you've really given that good thought already. We have a way forward. And having sat here from my first day here as a counselor, I will tell you the prior manager did not support this at all, nor did the council. I was like the only one that said, why don't we have a public defender's office? So we've come a long way over the last 4 years. I'm hoping we have. I'm hoping we do have that sense of urgency that we can do a lot better for the public and the efficiency of how the court system works. Again, it'll all be in the transition piece, and I'm hoping you meet every week with the court and the prosecuting attorney's office and the defense bar as it exists and our office that's managing the existing contracts. I'm hoping you meet at least twice a month to address any hiccups. So I would like to move forward with alacrity. I think now that we've had this presentation, let's go, let's do it. We'll start with I'm fully supportive of how you've, I know we're going to need a lot more attorneys than what you've got initially, but that's where the transition comes in. But it's a great start. Thank you for the presentations today from everyone. A lot of detail to follow, and I know you're up to it, Amber.
Chair?
Yes, Counselor?
Thank you. I have a few comments. First, I just want to thank you, Amber, for pulling everyone together and really thinking about this very complex issue. I think it's been overdue, and I appreciate everything that you've put together, and to everybody in the audience for sharing your perspectives on this problem. I met with a number of indigent defense attorneys, and I think this goes a long way to addressing some of the concerns that they've raised. I think whatever model we move forward with, there's going to be challenges. There'll be challenges any direction we go. I think cost will always hover over a concern in how to address this, and I appreciated those comments about it's the same work. It should be the same cost. If it's not, we need to identify how we're under-resourcing the problem. I think that was a very good comment. I am concerned, so I would say, yes, let's move forward in working out the details. I know that a couple of us received a letter from Ms. Carroll who went into some detail about the budget and additional staffing. So I think as this evolves, there may be some additional cost involved or additional staffing relating to investigative staff or a social worker. So I don't know if you want to address that right now or.
Yes, Councilor Marchand, thank you for sharing that with me as well, and Councilor Young did as well, so thank you both. What I would say to that is we know we're going to need, this is a foundational piece, right? And the two prior conversations that we've had with council, there was a lot of conversation around budget neutrality, and I think that's dangerous when we get into this kind of conversation of looking at it from a budget neutral. You take a contract away, you add an FTE. Take a contract away, you have an FTE. So I think that that's kind of the basis of a lot of the conversation that we've had in the past is that budget neutrality piece. We know that depending on crime ebb and flows in our community, some years we're going to have a lot high volume, some years we're going to not. And that's what I was talking about with the budget unpredictability when we have a contract model, is we're not able to flex up and down in an office. So if you hire someone that can do a point load of this amount, that's from the state level, but a contract, we only have these points because they have a private practice, there's no way for us to flex up. There's always going to be more cost, I believe, involved. I know that Katrina was talking about it should stay the same, but in reality, we're going to be paying higher costs because the amount of attorneys that we have that can do those cases are going to be less. We're going to have to pay more, and we're going to end up paying for it in the long run. Right. And so that's the piece. I agree with a lot of that Ms. Carroll had stated in her document. I just think that she's pulling a lot of her information from public records, and that's not always the most accurate information that she's getting. I think one of her points is that I'm using the step one of the attorney to base the salary expectations. I get my information from Emily, and they base it on a step 7 for management positions because they recognize you're not going to bring, that's what we're budgeted as. So the data that I'm pulling in from the budget comes from our budget office. It's not something that I'm creating on my own. So I just wanted to call that out there. But I do agree with a lot of her points. And OPD talked about the social worker aspect, the investigators. If we have those contracted in our community right now, of course, we pay for that with our contract attorneys. Those are areas we'll have to add on. The most important thing I felt as talking to all of our partners was getting those serious felony attorneys on board, recruited and retained for our office. Then we can add on the other pieces.
Great, thanks for that explanation. And then just based on what people have been talking about, if we know that there's going to be a huge backup related to body cams this fall, if there's some way we can try and ward that off if we know, it's coming.
Yes, and so we have purchased a professional license within the office for indigent defense. And what that will look like, and it took us a while to get there because, again, we were not at the table for the conversation that the prosecuting attorney's office chose for their portal. So there's different portals within the evidence.com. So we have we are going to purchase that. We're going to be the conduit for now. That's going to be a lot of stress on a 2-person office. That's what we have currently for our indigent defense office, plus me. So that is something that we're going to have to address, and that is going to be a choke point. It already is. And when the county comes on board fully. But we've seen that with the city. When I've had conversations with Tony's office, it's, that's about 50-50. 50 felonies percentage about comes from the city, and he said 50% comes from the county. We have to address this now before the county gets on board. So we are actively working on a Band-Aid fix in the interim. And I've also been in conversation with Chief McCabe and also Mike Sprinkler, IT director, to talk about how we don't make that mistake with the county side for our county sheriff's office piece and how we can meld those together. So we are working on that.
Great, thanks very much for that. And overall, I like the direction this is going. I think it's a very important component of the overall system, and we can't have it languish. Thanks.
Chair? You're on mute. I assume you said go ahead, but you are on mute. I'll go ahead.
I did, Counselor.
Thank
Please
you.
go ahead.
Thank you. So first of all, I would like to say, Amber, thank you. And thank you for all of everybody that came in and presented this morning. It's very helpful to get multiple different perspectives from all the different layers that exist and will be impacted by this. So I really appreciate that. And you can see the passion coming out of you as you bring this forward. So I just wanted to say that and appreciate it. And I'm very supportive. I think that this is a direction that we do need to go. I would like to ask if it would be possible, because I do really appreciate the comments from Ms. Carroll, if there's a way that we can provide her with the data so that she can be able to understand that and work with the data on that. That would be great. The one concern that I do have is the financing and the budget aspect of this, and I would like to learn significantly more about that. For example, you might be able to answer this right here, but the 1.38 million, is that just to get us this initial step, and then we're going to be increasing further as we further transition?
Yes, Councilor Young. So what that gives us is the FTEs, that's salary and benefits, that's calculated by the budget office. So that gives us the 7 attorney positions and then the 3 legal assistants to get that side of the office started. What I mentioned in the contracts transitioning out, of course, we have the 6.7 million that we pay in contracts on the general fund side. Those will start to decrease. As we let contracts go, that will start to go back to the general fund. And of course, that's a metric, and looking at how we track that as we transition, and Councilor Mevici talking about how important the transition piece is. That's an important component that Michelle Schuster and I and Emily have discussed of how we track how that comes off. So when we negotiate contracts for this year, for 2024, that'll have to be part of the conversation we have, is once we get folks on board, then we're going to be transitioning some contracts out. But as Ms. Emmerich stated, we can't even meet our contract obligations as we can now with the amount of contracts that we have in our county. And you see that with that over the hourly costs that we pay attorneys to catch up. So that general fund side, that's the contracts, the serviceables, that will start to dwindle down with that. And as we dwindle, then we can come back and add more. So that's been the goal, is looking at it from how do we take this initial investment, get it started, get quality people at the table, start to transition the contracts out, then we can look at what we add on that basis when the contracts start to leave.
Okay.
Yes.
Yes, so appreciate that, and I would love to learn more on that. So the other, concern that I have, and it's related to the discussion that we had last night regarding the public safety sales tax. Here we are looking at allocating 1.4 million. That's a good chunk of those funds. And I don't feel like we're ready to make that commitment at this point to come from those funds, because I don't think that we have adequately worked with the public to understand the directions they want us to take. I believe this program needs to be funded one way or another. It's that important. But how we fund it, I think before we dedicate those funds from the public safety sales tax, I think that we need to have a more robust discussion with the public. That's my personal thoughts on it. But again, I appreciate all this work, and I look forward to this moving forward in the future. Thank you.
Thank you, Councilor Young.
So, Madam Chair, we each will approach this job in a different way, but one of the aspects that I see in this job is, one, our due diligence and our research and working with the executive on all these issues and taking input from the stakeholders in this room today, but we have an obligation to lead, to make these decisions ourselves and to move forward. I don't need to wait for the public to tell us that we need a public defender's office. As far as a priority on our public safety sales tax, I think it is going to be a cornerstone of a sustainable benefit to the public safety sales tax to apply it in this way. We are the largest county in the state to not have a public defender's office. It is an inefficient use of taxpayer money. We need to fix it, and we now have the resources to do it. So I don't know what kind of input any counselor needs from the public to say, hey, that's a good decision, because I already know it is. And I think we have an obligation. We're elected for it.
Councilor Medvici, we had that discussion yesterday, and I completely concur with what you are saying. I'm less concerned, actually, at this point in time about the extent to which the public in general has been communicated with for reasons that Chris Cook and I both mentioned yesterday, than I am, has this been run by the Finance Committee? You mentioned several times this has been worked through the budget office, worked through the budget office, worked through the budget office. How about the finance team? Because they come at it from a professional perspective, representing many of the offices that you had mentioned, Amber, that you wish that there had been coordination with, and prosecutor's office, for example. So there would be others that could weigh in if that communication has thoroughly taken place as this moves forward. Has it?
So Chair, I have talked to Mark and Sarah about my proposal. It has not been ran through the way that I ran it through Emily. So if that's something that you would like me to do, I'm happy to do that from that perspective. But yes, I've talked to Sarah and Mark about the proposal.
And speaking to them, of course, is a great first step. It seems that the second step would be beneficial too, because greater perspective from the professional point of view would be obtained in that manner. Yeah.
I can happy to do so, Chair.
That'd be great. Thank you. Other comments from council?
Chair, I have a question. Thank you, Amber, for doing all this work, and I appreciate the testimony from everyone that's come to council. I have some concerns as well about the budget. Didn't you say that you would be providing us salary information, Amber?
Yeah, so what we would do is, since we're so close to Baker Tilly being presented to council in middle of July, I would like to wait till after that is proposed so that we can go at it with the actuals if that's approved by council. The classification and salary scale will be approved. Of course, that's under your purview to approve. It would be the same as the PA's office positions that I've listed. So basically, it would be a new classification that would be up on our website for the job description, and then it would be the same pay scale as listed at these below.
Okay, thank you. Yeah, that's what I was wondering about and how this would fit with our budget. But I'm interested in what Chair Bowerman mentioned as well, getting the finance piece of the puzzle and their perspective and input on it. But I absolutely support this as well, and echo what the rest of the counselors have already mentioned.
Thank you, Councilor Belcott.
May I turn to Kathleen Otto for a question on process, which she is often very helpful in getting us going the right direction from a process point of view. This morning is an important work session and certainly not the only in-depth discussion that we must have before really proceeding. What do you recommend for this morning to accomplish? Kathleen?
I think, thank you, Chair. I think we heard direction from council that overall supportive of the program. Based on the questions that were asked, Amber and the team can maybe bring back more budget information, and then the next step that she had outlined would be bringing forward a staff report for the FTE for council's consideration, and that would be after the Baker-Tilly study. And then once we have that approval, then they can start moving forward with hiring and recruiting for those positions.
So are we looking to mid-July for the next major step?
I would say yes, just because of holiday in there, probably mid-July for the budget update with the FTE requests, maybe end of July, beginning of August.
Comments from council on that process?
Sounds good.
Looking forward to it.
Well, I'm hearing thumbs up on that. So we could go on forever this morning, but we shall not do that. Is there anything else, Kathleen or staff, Amber, from your perspective that we must say and accomplish this morning?
I could hit my mic. I'm having tech issues too. I appreciate councilors' feedback, and I will take this to the finance team and get this together by mid-July for that. And just thank you for letting us take all the time this morning. This is such an important issue in our county, and our law and justice partners just so appreciate the council being open to hearing this discussion, and I appreciate the support. So I just want to say thank you.
You have the support, as do the people who joined you today, who are an integral part to this whole process. Thank you very much. And with this, I'd like to draw an end to this work session. And before we proceed on, I'd like to check with Kathleen Otto again regarding the remainder of the agenda. It is 10:45. And I do have some concerns about making it through everything that is before us in a methodical and thorough way. So Kathleen, would you comment on some possible adjustments? And then we'll talk about with council, are you ready for a break?
Okay, one thing, there is a second work session that is scheduled for this morning on the transportation system plan. It is about 15 to 20 minutes. However, in light of time, this can be pushed out if council wants to preserve that time for council time. And also during council time and at the beginning of council time, I will be asking to amend the agenda to delete item 2.2, which is the encampment policy and fencing. We're not quite ready for that discussion. And then just changing one of the potential litigation to pending litigation for 10 minutes. So there is a 40-minute scheduled executive session. The only other item that's on council time would be the fire impact fees memo that Oliver put together that is regarding the process for the fire impact fees, and of course, a work session request. So if council would like, we can certainly move out the other work session in light of time this morning, or we're ready to go if that's something you choose.
Council, I personally would support moving out work session number 2 so that we do have that time for council time, and the executive sessions being pushed out as you discussed, if that is passing muster with our legal team. And otherwise, the encampment policy and fencing, I had heard that discussion was not ready to proceed today. So that's nothing new. Although it is not particularly welcome in my book to be putting that off, I think it is something that has been proposed and is important to do. Are there, now if we do those things, I think we can make it through the agenda. Other thoughts from council?
Sure. If I may?
Yes, go ahead.
Yeah, if it's only 15 to 20 minutes, I'd prefer to move forward. We've had some high-level staff sitting here for over an hour and a half waiting to do so, and I don't want to have them wait another hour and a half at a different meeting too. But, oh, they would have been here regardless. Okay. Okay, all right, that makes things better. So I'm okay either way, whichever everybody else feels.
Very good. Other thoughts from council? I appreciate your concern for staff there, Councillor Young. Okay, hearing no objection particularly, I think we'll move ahead with that plan. And let me ask, I have forgotten what our break schedule is. I know some people really are eager for lunch. Is it that time? What is your desire? Would just as soon charge ahead and get it done, but that's me.
I'd
I'm
be
okay
happy
with
just
moving ahead.
going right into the agenda.
Are there others who concur with that? I think there are. So let's do that. I would propose a 10-minute break just to take care of getting fresh water and whatever else we need to do. And it is 10:49, coming back, meeting here, ready to begin at 11 o'clock. Does that sound acceptable? Okay, off we go. See you at 11.